Okay, so why don't you come on up and have a seat, please? All right, let me, I appreciate you being here on time. I noticed you were early.
Yeah.
So I will call you by Mr. What? How would you like to be referred to?
Call me Mr. Luis.
Mr. Luis?
Yes, please.
Happy to do it, Mr. Luis. Mr. Irwin, I see you here with Officer Schwim. Good morning to you.
Good morning, Your Honor.
All right, so Mr. Luis, you set the hearing. Have you had a chance to review the law that governs these hearings?
Yes.
Appreciate that.
I was going to ask you, are you pretty much working under your oath, like an oath of office to abide by the Constitution?
I'm a sworn judicial officer.
For the Constitution, right? To protect and uphold it?
Yeah, that generally is the basis and essence of my oath, yes.
Yeah, because I seen that we the people, that's pretty nice.
Okay, all right. Mr. Luis, before I look to the state, do you have any testimony you want to deliver to the court?
Yes, if I can.
All right, before you begin, and I'll let you know when to begin, do you swear to tell the truth under the penalty of perjury?
Yeah, I would say nothing but the truth that according to the Constitution, yeah.
Okay. Did you have any exhibits that you wanted to offer today?
I just wanted to read through pretty much the thing that I put together, showing like where I got this information and stuff, and how everything was done unjustly and without due process, and the violation of my rights under Title 18 to 42.
All right. So, Mr. Irwin, good morning. I see you have Officer Schwim. Are you ready to proceed?
I am, Judge.
Okay. Let me make a record as to what the court file has within it. I've received what's been filed, I should say, is a impound vehicle hearing request form signed by the petitioner. And I also have a second document, which is entitled Vehicle Impound Notice, which describes, in both of these documents, up in the left-hand corner, indicate Washington State Department of Licensing. I also have a carbon copy of a tow/impound inventory record filled out by Officer Schwim, indicating that the impound was made pursuant to RCW 4655-085, or 4655-113 and/or 9A88-140. Courts reviewed those statutes. I have copies of these statutes, and all right, that being the case, Mr. Irwin, you're standing up. Why don't you proceed?
Thank you, Your Honor. I've just received notice of this hearing this morning. I was, not aware of any subpoena that was issued. However, Sergeant Schwim did show up, explain the situation to me. So I'm ready to proceed under the infraction criminal rules, rather the infraction rules of district court, specifically Rule 3.3C, which essentially says that the court can consider all the documentation submitted as the state's testimony. I have not summoned Sergeant Schwim as my witness, so I'm going to rely on the rule. If Mr. Luis wants to, examine Officer Schwim, then that's his prerogative. But I don't have any questions beyond what has already been submitted, and would make that the state's case.
All right, appreciate that. I actually probably have a couple of copies for Sergeant Schwim, but Mr. Irwin, in reading the statute, it seems to me that the petitioner carries the burden, not you. Or do you believe you carry the burden to show the impoundment was proper?
I believe the defendant has he he's contesting the act.
Right. And he's the petitioner today.
That's
Yeah,
correct.
I agree with, I think that's the case also. So before I hear from Mr. Luis, morning, Sergeant. Would you mind taking the stand? I had a couple of questions, and then perhaps the petitioner might have a few. Sergeant, do you swear to tell the truth under the penalty of perjury?
Yes, sir.
Okay, thank you. Please be seated. Sergeant, would you state your last name and for the record?
Swim, SWIM,
Okay, and you are employed where?
Stevens County Sheriff's Office,
And your current rank is?
Sergeant.
Okay. Sergeant, this form that I have, the carbon copy that I described that you filled out, can you, what I can't tell from the document is, I do see that it's a trailer. Is that correct?
There was a truck, a trailer, and a car on the trailer. All three were impounded.
Okay, got it. And there are a number of statutory sites that you indicated you impounded the vehicles for. Do you know what statute in particular, or why was were these rigs in the roadway, or was the defendant arrested for driving without a license? I can't tell.
Do you want me to just tell you the story?
Yes, please.
So I was not the initial deputy that made the traffic stop. That was Deputy Felder, who's in surgery this morning, so I'm here on his behalf.
Okay.
I showed up late into this, and I did complete the impound forms for Deputy Felder. The basic story, the truck, trailer in tow, and vehicle on the trailer were observed coming off of Highway 395 into the Stoco parking lot. Deputy Felder was already there. The trailer did not have any plate on it, or an identifying license plate. Deputy Felder went to contact Mr. Luis and observed fictitious license plates on the truck and the car in tow. This drug out for a long period of time. He didn't want to initially identify himself. He later did. He was arrested for charges that aren't part of this hearing. We made the decision to impound all three at once.
He was arrested at the scene?
Yes.
Okay.
We made the decision to impound all three, the two vehicles and the trailer all at once. Applied for a search warrant to obtain the two fictitious license plates and the VIN number off the car in tow, which was not, it wasn't visible from outside the vehicle. It was covered on the dash. So Deputy Felder did ultimately apply for and was granted a search warrant. He did go do exactly what he intended, which was take the fictitious license plates and identify the car, identified that the trailer had never been licensed, didn't have a VIN number, homemade trailer. So long story short, none of these vehicles were legal to be on the roadway in the state of Washington, which is why they were impounded.
All right, thank you. So, Mr. Luis, I'm going to grant you permission to question the sergeant.
Yes.
I recognize you're not, or you are not a lawyer, correct?
Yeah, correct.
All right. So, I would like your questions to be delivered in a polite fashion, and I would like your questions to be related to the facts. I don't want any legal questions regarding the officer is to testify factually. If you have any legal questions, please pose those to the court. Okay? All right. Go ahead and question Sergeant Swim.
Mr. Swim, do you know the definition of a driver?
Mr. Luis, I think that question is one that I gave my initial preliminary statement to you about.
Yeah, well, wouldn't you have to know that, being an officer and doing traffic citations?
It doesn't matter to the court whether or not the sergeant understands the legal definition of a driver. He is a sergeant with the Stevens County Sheriff's Office. Let's move on to the next question.
So according to RCW 1031-100, arrest without a warrant, did you guys end up doing this, arresting me without a warrant?
All right, I've got it. I appreciate that, Mr. Irwin. Okay, so right off the bat, this is the second question. It's a legal question being posed to the sergeant, which, again, he doesn't have to answer. The issues for this court and this hearing are whether or not the vehicles were lawfully impounded under the statutory sites cited by the statute. That's it. So, next question.
Well, I'm just trying to understand or know what you're trying to say exactly, because would I just be able to just go over this, like without having to question him?
You don't have to question the sergeant. That's fine if you'd rather not. Would you like to just read your statement into the record?
Yeah.
All right, Sergeant Swim, would you please step down? Thank you. Okay, Mr. Luis, I appreciate you coming prepared, and you have a statement. Looks like to me that's written out. How many pages do you have?
7. So it only take about 15 minutes.
All right, I'll give you 15 minutes. Go ahead, please.
All right. So yeah, this is a motion of definition of right pertaining to commerce and travel. And this is an introduction. This motion seeks to clarify the definition of legal, meaning pertaining to commerce, drivers, operators, and the right of the citizen to travel upon the public roads alongside the implication of licensing and regulation imposed by municipal and state entities. 2, the definition and legal meanings. I want to go into what the meaning is of commerce. Intercourse by the trade and traffic between different people or states and citizens of inhabitants thereof, including not only the purchase, sale, and exchange of commodities, but the instrumentalities and agencies by which is promoted and the means and appliances by which it carries on, and the transportation of persons as well as goods. And that there's citations, Vernon versus Titusville, Railroad Co. versus Fuller, there's a few others. And then I wanted to go to the definition of a driver because I stated to Swim that I wasn't driving. I told him I was traveling. It's actually a constitutional protected right that the Supreme Courts have upheld plenty of time.
Let me ask you something. I'm sorry to interrupt. Can you appreciate that you wrote something or maybe wrote something with somebody else and thought about this, but are you able to summarize your argument to the court without reading that? And I'm not trying to trick you. I'm not.
Yeah.
But the gist, are you contending that you should not have been arrested because you were lawfully driving on the roadway and didn't have to have valid license plates? What is your argument precisely, if you can?
Yes, well, that's the argument is that I wasn't driving. When I was inside Spoco Fuel about to put fuel into my truck, they actually came up to me and asked me that if I can identify, and I told them no, unless there is a crime being committed, then that's the only reason for me to identify. So I told them, articulate what crime I committed, and they couldn't. They were pretty much just saying, oh, well, your trailer doesn't have a license plate and all that, and no registration. I told them, well, unless there is a crime being committed, that's the only grounds for you to ask me for my information or to do anything about this. And because I told them that the definition of a driver, and I told them, exactly what it says here, and then also that if someone is not driving or doing anything in commerce, then there is no need for a driver's license or registration or insurance. And
I got you.
Yeah.
I hear you. Okay, so you can either read that into the record or you can mark it as an exhibit. What would you like to do?
Yeah, I wanted to read this.
Okay, I won't interrupt you anymore. Go ahead.
Thank you. All right, so it's driver as a Bovier's Law Dictionary, 1914. It says one employed or conducting a coach, carriage, wagon, or other vehicle. So it specifically says one employed. Also in the Black's Law Dictionary, 3rd edition, it says one employed in conducting or operating a coach, carriage, wagon, or other vehicles. And then in the Black's Law 4th edition, it also said one employed. And then the cops were, the sheriffs were using all these commercial terms because obviously if we read all these definitions, they're all based on commercial terms. So operator says New Bill versus Union Indemnity Code says to further clarify the definition of an operator, the court observes that this was a vehicle for hire and that this was in the business of carrying passengers, and that was under the new bill versus union indemnity. So, and then the number 3 legal framework, section A is 18 U.S. Code section 31 definition of a motor vehicle, because they were using that word as well for that term. It says the term motor vehicle means every description of a carriage or other conveyance propelled and drawn by mechanical power and used for commercial purposes on the highways to transport passengers and property or cargo. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or direct or indirectly in connection with the business, or other undertaking intent for profit. And the public roads, the definition of public road is a roadway exiting from the free and unrestricted use of all common people in a public road. And the citation is Inninger versus Perry. And there's the definition of traffic, because that's what a lot of these cops do, is they give you traffic tickets. And knowing the definition is important. So in Bovier's Law Dictionary 56, the traffic means commerce, trading, sales, or exchange, or merchandise, bills, money, and like. And then traffic in Black's Law Dictionary 3rd edition, commerce, trading, sales, or exchange, merchandise, bills, money, and like. And then Black's Law Dictionary 6th edition as well, commerce, trade, or exchange of bills, money. The case reference for traveling and licensing rights. Justin Tolman of the Washington Supreme Court terms this. It says, travel is not a privilege requiring licensing, vehicle registration, or forced insurance. That's Chicago Coach Co. versus City of Chicago. The Supreme Court makes it clear that a license relates to qualification to engage in a profession, business, trade, or calling. Thus, when merely traveling without compensation or profit, outside of business, enterprise, or adventure with a corporate state, no license is required of the natural individual traveling for personal business, pleasure, or transportation. And then the citation is Wingfield versus Fielder. And complete freedom of the highways is so old, well established a blessing that we have forgotten the days of robber baron, the toll roads, and yet under an act like this, arbitrarily administered, the highways may be completely monopolized. If through lack of interest the people submit, then they may look to see the most sacred of their liberties taken from them one by one, by more or less rapid encroachment. Citation is Robertson versus Department of Public Works. The United States Supreme Court has stated, we are of the opinion that there is a clear distinction in the particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for examination on the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to investigation so far as it may tend to incriminate him. He owes no duty such to the state, since he receives nothing therefrom beyond the protection of life, liberty, and property. His rights are such as the law of the land long extended to the organization of the state and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are the refusal to incriminate himself and the immunity of himself and his property for arrest or seizure except under warrant of law. He owes nothing to the public so long he does not trespass on their rights. Citation is Hell versus Hinkle. Furthermore, upon the other hand, the corporation is a creature of the state and is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the law of the state and the limitations of its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. This is a reserved right in the legislature to investigate its contract and find out whether it has exceeded its power. It would be strange and anomaly to hold that the state, having chartered a corporation to make use of certain franchises, could not in exercise of its sovereignty inquire how those franchises have been employed and whether they have been abused and demand the production of the corporate books and papers for that purpose. Corporations, well, that's citation Hell versus Hinkle. Corporations engaged in mercantile equity fall under the preview of the state's admiralty jurisdiction, and the public at large must be protected from these activities as they are engaged in business for profit. In order to reach the full understanding of the right versus privilege, it is important to know that the court have ruled consistently without ambiguity no sacrifice exists. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which could abrogate them. Citation Miranda versus Arizona. The claim and exercise of the constitutional right cannot be converted into a crime. Citation Miller versus U.S. See also McLean versus Department of Homeland Security. And number 5, curriculums of the law and legislative intent. So, and like I said before, the 18 U.S.C. 31 definition of motor vehicle, we went over that before. So I'll go down to the curriculum of the law school is expressed through this writing as indicated above. The law school presents that special statutes trump general statutes and that particular words trump general words. The same theory of law was expressed in the policy intent by the Washington State Legislature at RCW 46.25.005 as follows. To the extent that this chapter conflicts with general driver's license provisions, this chapter prevails. The special commercial motor vehicle provision of 46.25 trump and prevail over the general license proviso of 4620. That is proof positive that all licenses are in fact commercial. As we can see that whenever someone does Uber driving or taxi driver, or if they're just delivering a pizza, they need a driver's license because they're operating under, actually for gain or for a fee. And then we know of no inherent right in one to use the highways for commercial purposes. The highways are primarily for the use of public and the interest of the public. The state may prohibit or regulate the use of highways for gain. The citation Robertson versus Department of Public Works. The legislature does not have the power to abrogate citizens' rights to travel upon the public road by passing legislation, intimidating the citizens to waive the rights and convert the right into a privilege. Furthermore, we have previously established that the privilege has been defined as applying only to those who are conducting business on the streets or operating for hired vehicles. It is well known by the state and its agencies that there is an absolute distinction between private traveler and commercial traveler. When reversing the Motor Vehicle Act, it is critical that the definitions used therein are strictly adhered to. It is further extremely technical that in order to enforce a motor vehicle code, the state by any branch must adhere to and comply with the whole Act rule. Any prosecution, civil or criminal, commenced pursuant to the Motor Vehicle Act must be in fact commercial, and it is the sole obligation of the state to prove that the act in question was in fact commercial. Number 6, former Attorney General opinion, the following is a formal Attorney General John J. O'Connell opinion that the intent of the application of operator and driver's license. Mr. O'Connell, as a former representative of the state of Washington, agrees that all states relating to operating and driving are static, as well as conforming to that all licensing issues by the Department of Licensing are in fact issued for higher status. By the use of Latin legal maxim, expressio unius est ecclesio ulterius, he acknowledges that no license may issue for personal use of an automobile. And number 7, relevant case law on unlawful searches and seizures. Chicago versus Bank, the case turned upon the question of whether the city of Chicago had the power to, by ordinance and in the absence of a statute, to require an automobile owner to submit to an examination and to take out a license before he should be permitted to use his vehicle for his private and personal pleasure. The court, in declaring the ordinance void, held that inasmuch as that was no statutory provision on the subject, the charter of the corporation is the measure of the power, and the enumeration of those powers implied the exclusion of all others. In the context of this case, the case focuses on whether the city could require automobile owners to undergo an examination to obtain a license to use their vehicle for personal use without supporting state statute. The legal question, the court needed to determine the city how the power to enact such an ordinance. This revolves around the limits of municipal authority, specifically whether a city can impose regulations that are not explicitly authorized by state law. The ruling, the court declared the ordinance void, meaning it was not legally enforced, and the reasoning was based on the principle that a city's authority is defined by its charter. The foundation legal document outlined its powers. The implication of the power, the state enumeration of those powers implies the exclusion of all others, meaning that if the city's charter explicitly lists certain powers, they cannot assume other powers that are not mentioned. In other words, if the charter does not grant the power to require license for private automobiles, then the city does not have the authority. And then B, American Judiprince Second Automobiles, Section 16. Now, the judicial branch in the co-conspirator in the initially legislative, subsequently executive licensing scam, private travelers run the risk of being stopped and harassed for not having license plates or other personal property automobiles or a driver's license. But by what authority? Clearly that the state has no authority or jurisdiction concerning private affairs. This right goes back to 100 years to get a resolution as the licensing scheme. The fact that the police use commercial license statutes to interfere with personal affairs is clearly inconsistent with the history of and the intent of the driver's license. The statutes are void for vagueness, as being overly broad, and void for want of substantive due process by failing to provide notice and distinction in the traveling, whereby not clearly and succinctly delineating the difference and establishing proper authority and jurisdiction guidelines. And the public health and safety, note that the correlation of the public health and safety, the personal private use and enjoyment of the highways is neither an existing threat as in the former nor an impending threat as in the latter. The state uses a private for-hire classification in one statute, and the vague written driver's license statute is an attempt to superstitiously create or manifest some potential threat generated by all who use the roads on the highway. These may be construed as fraud, because the court and the Attorney General and other statutes have already confirmed that it is commerce that creates that threat. And then number 8, unlawful searches and seizures. The best of a crime, the application of Texas statute to detain the appellant and requiring him to identify him violates the Fourth Amendment because the officer lacks any reasonable suspicion to believe that the appellant was engaged or has engaged in a criminal conduct. Detaining an appellant to require him to identify himself constitutes a seizure of his personal subject to the requirements of the Fourth Amendment that the seizure be reasonable. Citation Terry versus Ohio. and United States versus Brigham and Hans. The Fourth Amendment requires that such a seizure are based on specific objectives. Facts indicate the society legitimate interest requiring such actions, or the seizures be carried out pursuant to the plan, embodying implicit neutral limitations on the conduct of individual officers. The citation is Delaware versus Krause. Here, the state does not contend that appellant stopped pursuant to a practice embodying neutral criteria, and the officers were not justified on the grounds that they had a reasonable suspicion on the objective fact that he was involved in a criminal activity, absent any force suspecting appellant or of misconduct and balance between the public and crime prevention and appellant's rights to personal security tilt in favor of freedom from police interference, as Brown versus Texas. Number 9, the corpus delicti, which I brought up plenty of times, and they never, they just went against it. It says, furthermore, proof of the corpus delicti is required in all criminal cases. There are 3 basic elements in the proof of crime. 1, the occurrence of loss or injury. 2, the criminal causation of the loss or injury. And 3, identity of the defendant as the perpetrator of the crime. However, it is firmly established in the state that the term corpus delicti embraces only the first 2 of these elements, loss or injury and criminal causation, State versus Hill. Without the injured party, there can be no crime. That's Sherry versus Collins. In 1973, it was noted, without corpus delicti, there can be no crime. The Supreme Court has reinforced this view in People versus Lopez. In every prosecution for a crime, it is necessary to establish the corpus delicti. And then I did find an RCW that brought this out, which was arrest without warrant, RCW 1031-100, which I know that we don't go by RCWs as a people that go by the Constitution, or the Constitution is actually made for the officers. Any police officer having probable cause to believe that a person has committed or is committing a misdemeanor or gross misdemeanor involving physical harm or threat of harm to any person or property or unlawful taking of property. And the conclusion is, in the light of the definitions, case law, and constitutional protections discussed, it is clear that the licensing scheme imposed by the state and municipal authorities may lack constitutional grounds when applied to private travelers. We urge the court to recognize the distinction between right secured by the Constitution and privileges that can be regulated.
All right, Mr. Lewis, I appreciate your polite presentation of that statement to the court, and as I said, your preparation. Sergeant Swim, I had some follow-up questions.
Sure.
And you can just stay seated, please. The officer that pulled over Mr. Luis, his
Deputy
Feldner, and it was a traffic stop, is your understanding?
Deputy Feldner was already at the
Hey, Mr. Luis, just, I see you.
Yeah.
I'm doing something. Just pay attention to the answers and questions. We'll get back to it. Go ahead, Sergeant.
Deputy Feldner was already out of his vehicle at the Spoko gas station. Observed this vehicle, trailer, and car in tow on the trailer come off of 395 into the parking lot, and that's when the contact was made.
And he noticed the
No license plate on the trailer whatsoever, and then the fictitious license plate on the truck, and later on the car in tow.
Is there a reason you can't state what the defendant was arrested for, or can you?
I don't recall. I believe it was obstructing, but I don't recall what Deputy Feldner arrested him for. My part in this was staying there, doing the impound sheets, making sure Mr. Louise's wife and children had a safe ride home.
Appreciate that. Is there any other testimony you want to deliver to the court, even if it's not made pursuant to a question?
This simply involves around the impound and not the charges that he was arrested for, correct? Whether the impound was lawful or not, I don't have anything else to add to that.
I appreciate that. Mr. Luis, you made your statement. Is there any other thing you'd like to present to the court?
Yes, I was just talking about Glenn illness. I was actually not pulled over. I was in the gas station, already about to pump, and I seen his truck come around and get into the parking lot, and then he circled around and looked at my trailer that didn't have license plates, and then he circled around one more time and stopped right behind me and then got off and talked to me.
All right, thank you. All right. Mr. Irwin, any comments?
No.
Sergeant Swim, anything else?
I can just add to what he said. It's not inaccurate. Deputy Felder was in the store. His truck was parked behind the store. When he observed this vehicle and trailer, he went out the back door, got in his truck, drove around to contact him. So he had all of his tools, his computer and so forth right there to do his job.
Okay. Mr. Luis, did you want to offer any testimony regarding the your arrest, regarding what you believe the basis was, or did you just not want to address that?
Oh, yes. Well, just the whole thing about taking my private property without due process was, you know, a violation of my rights. And just the fact that my children and everybody was with me, and we were pretty much left with no form to travel with. And now I have to borrow, you know, other cars from other people, and it's pretty sad, you know, to just see that someone is privately violated in that form just for not even a crime being committed. There is no accusing part. I mean, no injured party, or you know, there's nothing like that they can pretty much go against me with. You know, there has to be purpose like that. There wasn't, and just the whole fact about you know, the Fourth Amendment, like they didn't uphold their oath that they took, knowing that there was no crime being committed, and they searched me without a warrant, and they arrested me without a warrant. It's just so messed up to see what this country is coming down to. That it's like Nazi Germany, you can't even freely travel without being harassed, you know, around here. And as we know that.
I'm looking to the clock, so I'll give you 30 seconds to wrap it up. Go ahead.
Yeah, and just to know that you know, anything that has to do with driving is in commercial capacity, and I wasn't doing so. I was just taking my trailer with my car on it, which needed to be fixed at the mechanic shop. I wasn't driving in any commercial capacity. I was traveling.
Okay, I appreciate that. So the court has taken testimony and listened to the parties, and the court recognizes Sergeant Swim as being at a sergeant level and has been employed as a deputy with our sheriff's office for a number of years and is experienced in these matters. I also noticed that God-fearing towing company and storage was involved, and they are routinely involved with the sheriff's office in terms of towing and storing vehicles, and they have some sort of agreement or understanding, I suspect, with the Stevens County Sheriff's Office, and that there was nothing unique here about these particular circumstances, either with Sergeant Swim or God-fearing. This court is confined to consider whether or not the impoundment of this vehicle is lawful under RCW 4655-120, and that's the issue for the court. And I do recognize, Mr. Luis, that having your property seized and moved to another location, and I suspect locked at that location, is significant, and it's not taken lightly. And we have a procedure and process in this county, as does every county, and we have this impoundment inventory document filled out by Sergeant Swim. It seems to be in order. It is in order, not seems to be. I've considered his testimony as well as the statutory basis for authorizing impoundment, and they're met in this case. So you made a presentation today, Mr. Luis, regarding, I think, your ability to be on the roadway free from encumbrances from law enforcement, whether it be a stop or questioning or detainment for a period of time. It's well settled in Washington that persons must have valid driver's license, and it's well settled in Washington what the statutory and constitutional basis are to allow law enforcement to make stops and detentions and even arrests in this state. The court's not finding that anything occurred was unlawful, although that's really not the gist of this hearing. Although maybe if I found that your initial detention was unlawful, it might go to whether or not the impoundment was proper, but I'm not finding that to be the case. There's nothing extraordinary. The arguments that you raise, frankly, have been rebuffed by our appellate court for a long time. So what you offer to the court is not unique by way of the recitation of your legal arguments. All right, that being said, I'm going to make a finding that the impoundment was proper under RCW 4655, regardless who carried the burden in this particular case. And I'll issue a written order by the end of the business day today. So, Mr. Luis, you may come by and get a copy of the conformed order today before we close at the district court. Do you have any questions, Mr. Luis?
I don't get how all of this can happen, you know, and you guys still go against the Constitution. You were saying that, you know, it's been rebutted, but it actually has been upheld by Supreme Court, which is higher than all of you guys. You know, that they have the last say on all this.
Yeah, I don't know if you've researched that yourself or you received that document that you read from somebody else that you might be working with. It doesn't really matter, but it's off the mark completely as far as Washington law goes. It's not compelling in any way, and it's rejected by this court in its entirety. Okay, that being said, we're adjourned for the morning.
All rise.